Kaya gusto ko pong itama yung medyo hilaw pong interpretation ng ating Honorable Marcoleta.
Ito ang banat ni Senator Panpilo Lacson laban sa kanyang kapwa-senador na si Marcoleta. Ang sabi ng senador, hilaw ang interpretation ni Marcoleta sa Section 135 ng Senate House Rules. Ito ay may kinalaman sa mosyon ni Marcoleta na i-dismiss ang impeachment na kung saan ay iginiit ni Lacson na wala sa rules ang motion to dismiss.
Kasi wala po sa rules natin yung motion to dismiss.
Dagdag pa ni Lacson.
Mr. President, gusto ko lamang pong itama ang misimpression that may have been created by the interpretation of the Honorable Marcoleta do sa Section 135. Wala naman po ako nakita do sa enumeration na rules of court.
Ano nga ba ang nilalaman ng Senate House Rules 135? Pakinggan natin si Senator Marcoleta.
Pero may I invoke Section 135 of the Senate Rules? Ang sabi po rito, if there is no rule applicable to a specific case, the precedents of the Legislative Department of the Philippines shall be resorted to. So ang dami po nito. Dito po magkakaroon ng motion to dismiss dito. Lahat po ng precedents, kahit na wala po tayong specific rules, ay observe po natin ang Section 135 ng ating rules.
Panoorin natin ang buong detalye. Pero bago yan, huwag kang limutang mag-like at subscribe para sa mga pinakabagong balita.
So desires. Thank you, Mr. President. This is not an interpellation. Rather, this is a manifestation to be followed by a parliamentary inquiry.
The gentleman may proceed then.
Mr. President, I've been diligently reading and reviewing the rules of the Senate since I've been out of this august chamber for 3 years. Nowhere in our rules can I find a provision on a motion to dismiss as submitted by the Honorable Gentleman from Tarlac. Neither is there a supplementary application of the rules of court to offer a space for such motion to dismiss, except perhaps in the committees performing their legislative inquiries in aid of legislation. Obviously, we are now assembled in plenary, not as an impeachment court, but as a legislative body, and I cannot relate to a motion in this plenary to an issue that involves a collective decision that falls solely and exclusively under the jurisdiction and authority of an impeachment court. Having said that, Mr. President, my parliamentary inquiry is addressed, of course, to the Senate President. Mr. President, how do we deal with the pending motion? I refer to the motion to dismiss. Shall we even take it up or deal with it? Kasi wala po sa rules natin. Paano wala tayo pong guidelines? Kasi wala po sa rules natin yung motion to dismiss. So anong guidelines ang susundin natin in addressing the motion to dismiss submitted by the Honorable Marcoleta? Assuming arguendo, Mr. President, that the motion is voted upon and adopted by this body, what if, Mr. President, the Supreme Court reverses itself when it rules on the MR filed by the House of Representatives through the Solgen? Shall we also backtrack and reverse ourselves in dismissing the impeachment case? I pose that question, Mr. President. Thank you.
Thank you, Senator Lacson. To respond, we were faced with this question, but the very people asking us to wait right now were the very same people who were telling us before to ignore the pendency of a case in the Supreme Court precisely regarding this impeachment complaint. They were egging the Senate, even if we were on recess, to precisely proceed with the trial in spite and despite the pendency of cases in the Supreme Court. And the chair, with an abundance of caution, same with us good senator right now, decided to afford the Supreme Court time during the recess to decide on the matter. And when they did not, the Senate, in accordance with its duty, convened the impeachment court when we resumed session, given that we cannot conduct impeachment proceedings that have not yet begun yet during the recess. to answer the query with respect to motion to dismiss, this was actually done, although not via a motion to dismiss, but a motion to archive in relation to the impeachment complaints of then President Estrada and Ombudsman Gutierrez. In fact, in the case of Ombudsman Gutierrez, it was our distinguished minority floor leader himself, acting as majority leader, I believe, who moved that the case be archived, given the resignation of then Ombudsman Gutierrez for being moot. In the case of President Estrada, the case was likewise archived for being functus officio, given that EDSA DOS happened and a new president was sworn into office. Your Honor, I believe the chair believes that we will have different interpretations of the effect of the Supreme Court decision. But ultimately, as I discussed with the majority leader earlier, once a decision is made by the Senate and the period to seek a reconsideration of that decision put to a vote has expired, the next logical step would be to archive so that it will be made part of our records. It is the position of the chair, subject to the wisdom of the plenary, Your Honor, that given the Supreme Court decision that the Senate never acquired jurisdiction over it, that the proceedings and the articles of impeachment were null and void ab initio. Indeed, there might not even be anything to dismiss, and the procedure would be more properly to archive, similar to what we have done in the past, so that these proceedings will still be made part of the Senate's records. But we will cross that bridge once we put it to a vote, Mr. President.
I go
Your
back
Honor.
to my previous question, Mr. President. Anong gagawin natin sa motion to dismiss? How do we deal with it?
May
We
I
are in
answer,
plenary
Mr.
as a legislative body. We're not an impeachment court. So yun ang tanong ko po, Mr. President. Yun ang essence ng aking parliamentary inquiry.
The predisposition of the chair is what I stated, but subject, of course, to the wisdom of plenary. Maybe here from Senator Marcoleta, with respect to his ideas, given that he is the proponent
Mr.
of the
President,
motion.
it is true that the motion to dismiss is not part of our rules. But it is part of our rules po yung pagiging suppletory application po ng rules of court. In the rules of court, yung korte po can motu proprio dismiss a case kung wala pong jurisdiction. And considering that the rules of court has become part of our rules, that's why I use the motion to dismiss. Pag wala pong jurisdiction, halimbawa, sa isang korte, collection case po ito, 5,000 pesos po yung pinahal niya, dinismiss po ng court kahit hindi pa sumagot yung kalaban, Mr. President, kasi ang jurisdiction po ng korte hanggang 3,000 lang. Ganun po ibig sabihin nun. Minsan po, hindi po verified yung complaint, dinismiss. Sa motu proprio, talagang dinidismiss. Paano po kaya kung sinabihan pa nga na the Senate didn't acquire jurisdiction over the case? Mas lalo po sigurong dapat nating panindigan na talagang i-dismiss na po natin, Mr. President.
Senator Lacson is recognized.
Again, I refer to our rules, Mr. President. Wala rin po ako makitang suppletory application sa rules of the Senate pagdating sa plenaryo. Pwede pong gamitin ito sa mga committee hearings.
Sa impeachment.
Inquiry in aid of legislation. But we are not there. We're here in plenary. Maski po basahin natin na 100 beses ang ating rules of the Senate, wala pong suppletory application sa ating rules. Thank you, Mr. President.
The point of Senator Lacson insofar as that is concerned is well taken. Senator Pangilinan.
Just on the point of
Is recognized.
suppletory, the rules of court being suppletory. Mr. President, the rules that are suppletory presupposes that there are no rules of the Senate or the Senate impeachment court. In other words, in the absence of a standing rule or provision of either our Senate rules or the Senate impeachment court rules, then we refer to the rules of court as suppletory to our rules. But in this case, the Senate impeachment court has a specific rule, Resolution number 39, Upon presentation of the articles to the Senate shall specify the date and time for the consideration of such articles. Unless the Senate provides otherwise, it shall continue in session from day to day until final judgment shall be rendered, and so much longer as may in its judgment be necessary. In other words, as an impeachment court, of course, not as a Senate in plenary, but even that is now being debated because this representation believes the sole power to try and decide impeachment cases is the impeachment court and not the Senate in plenary.
Mr. President,
Majority Floor Leader.
Mr. President, next to interpolate, Mr. President, on the list of this representation is the distinguished gentleman from Taguig and Pateros, no other than Senator Alan Peter Cayetano. I move that he be recognized, Mr. President.
If I may, Mr. President, with the indulgence of the good gentleman from Taguig and Pateros, yung akin po ay
The lady may proceed.
susog doon kay Senator Lacson ng mga punto.
But, Your Honor,
It's
the
not an
chair-
interpellation yet, Mr. President. I follow up point to the point of Senator Lacson. If the SP
lady may
and
proceed.
the gentleman. Thank you, Mr. President, and with the indulgence, as I said, of the good gentleman from Taguig and Pateros, nabanggit na rin po, Mr. President, pareho ni na Senator Lacson at Senator Pangilinan, yung usapin ng tayo ba, Senate or Senate impeachment court ba? So this is a point of inquiry, actually, a brief point of inquiry, Mr. President, related to the motions at bar now. The question presented to the body is related to an ongoing impeachment case, which is within the jurisdiction of the impeachment court. Should we not first have the newly elected senators take their oaths as senator judges and convene as an impeachment court? I note, Mr. President, that the Supreme Court decision is not yet final. As colleagues have mentioned, a motion for reconsideration has been filed by the House of Representatives, and the court itself, the Supreme Court, has given 10 days for the Vice President to comment. So yung point of inquiry ko nga po, Mr. President, hindi po ba dapat pasumpain na muna ng presiding officer with us convened as an impeachment court, yung mga bagong halal na senador para makapag-convene po tayo bilang impeachment court at i-treat yung mga motions at bar. Salamat po, Mr. President.
Noted and entered into the records. What is the pleasure of the Honorable
Just a very quick intervention. Very quick, Mr. President. With the
Pangilinan?
permission of
Yes,
our-
you may proceed, sir.
Yes, Mr. President, and we place this on record after reading the ruling, the decision of the Supreme Court. Mr. President, the Supreme Court referred to the Senate impeachment court repeatedly. And therefore, it is the Senate impeachment court that was also impleaded. It is the Senate impeachment court that may, if it opts to, file a motion for reconsideration. And therefore, this motion to dismiss, we believe, should be forwarded to or tackled by the Senate as an impeachment court.
Your Honor, just on that point, the parties mentioned in the case is not the Senate impeachment court, but the Senate. And the dispository section of the decision makes mention also of the Senate. If I may quote, consequently, the Senate did not acquire jurisdiction to constitute itself as an impeachment court. That's the decision of the court in Duterte v. HOR.
Mr. President, and we will go back to the earlier manifestations
The
of...
mic, please.
We will go back to the earlier manifestations of the minority leader. Yes, the Supreme Court ruled that we have no jurisdiction. Yet, the decision is flawed in terms of the facts on procedure, the one-year bar, and on due process. This is at least, of course, our assertion. And therefore, should we not wait for a motion for reconsideration to be resolved before we proceed and vote on the matter that has removed from the impeachment court jurisdiction? Should we not at least assert the power and the prerogative under the Constitution of the Senate Impeachment Court in terms of the exclusive jurisdiction, number one, and the sole power to try and decide.
That is what we will be deciding and voting upon this afternoon, Your Honor.
Thank you, Mr.
Senator
President.
Cayetano is
Yes,
recognized.
please, Mr.
Thank you, Mr. President.